The November 14th, 2018 meeting of the Municipal Code Enforcement Board is called to order. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. For you that walked in when we were all sitting up here discussing, you walked in on a training session, so you didn't miss any part of this session. So, ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by this quasi-judicial board will be based on evidence and facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violation. The respondent will then present his or her case. Both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chair and must address the board from the podium after giving their name and address. Upon request, copies of materials submitted by the staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the city attorney. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the Deputy City Clerk.
Please raise your right hand if you plan to speak. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
Cases will be taken out of order to accommodate respondents and witnesses present at tonight's meeting. And for board members, to give you some heads up for paperwork, under hearings, 18376 is going to be number 1. 83726. Number 2 is going to be 18-3880. Number 3 is going to be case 18-3917. Case 4 under lien reductions, 101146, be number 4. And number 5 will be case 102154. Okay.
The first case, case number 183726.
Oh, excuse
wait.
me,
Yes.
one thing, sorry. We had minutes for last month's meeting.
Yes.
Has everyone reviewed them and had time to review and any comments, corrections? Could then I get a motion?
I'll make a motion to approve the minutes.
I'll second that.
Motion by Lloyd, second by Newkirk. Yeah. All in favor?
Aye.
Opposed? No nays.
I don't know if it needs to be on the record that it was the minutes from the last municipal code enforcement meeting. What the date was. That would have been October 9th,
10th.
October 10th.
10th, sorry. 10th, there you go. Just have it read in the record.
Okay,
Thank you.
so be it. First case.
Ex parte first.
parte communications regarding any of the matters that are coming before the board this evening. If you had any verbal communications, if you could disclose with where they occurred, with whom they occurred, and when they occurred. And if there's been any written communications, if you could please disclose the sum and substance of those communications and then present it to the clerk to be placed on the record.
Mr. Plow?
None.
Snelling? Knupke?
Nope.
Schmidt? No?
None.
None.
None. Thank you.
The first case, case number 183726, City versus Rodney Thomas and Amanda L. Hairston Thomas for property located at 8644 Navajo Avenue. Case is before the board based on alleged violation of Section 12859, subsection 3, RVs, boats, and trailers nonconforming. The case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman and board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on August the 24th of 2018. My inspection on that date revealed a trailer in the side yard unscreened from view. I left a door hanger with a reinspection date of August 31st, 2018. My inspection on September 7th, 2018 showed no change, so a notice of violation was prepared with a compliance date of September 24th. No one was at home, so I posted the notice at the home as well as at City Hall, and copies were mailed, both certified and regular mail, to the address. My reinspection on October 26 revealed no change, so a notice of hearing was prepared and the case was scheduled for the November Municipal Code Board meeting. At this time, I'd like to submit photographic evidence of the violations taken by me on November 5th, 2018.
Board will accept.
Exhibit number 1 shows the unscreened trailer.
Is that unscreened from the front?
Yes, sir. Unscreened from the front and at that point, the right side, which would be the east side of the trailer. I have been in verbal contact with the property owner, and he said he would correct the violation, and I do believe they're here. But as of this time, the site is still out of compliance, and we're requesting a ruling.
Okay. Are there any questions of Mr. Allen? The respondent is here.
Yes, sir.
Please come up.
Good evening.
Name and address, please.
Rodney Thomas, address 8644 Navajo Avenue.
Excuse me, I've lost my voice. Amanda Thomas, 8644 Navajo Avenue.
Thank you.
Pretty much guilty as charged. The gentleman, he informed me several times, and just it was my ability to be king at procrastinating to not get it done. So I will definitely get it taken care of. I actually already have the fence over there. There is a lead time on having the gates manufactured, though, so those will be 3 to 4 weeks out, I believe. But like I said, I already have the fence over there, so I will actually have that done by the weekend. But again, with the fence, or the gate rather, there is a lead time on it.
Rodney, were you starting to put up the fence before the violation, or is the whole fence a result of a violation?
The whole fence is a result of the violation.
It's a nice fence.
Oh,
Looks great on the pictures.
Oh, yeah, thanks, but that wasn't the part where I'm parking it on my empty lot, so that's the part that I need to get fenced in, so.
Okay.
We had plans to actually fence it all in, but we got the notice for the violation. So again, he should have done it faster, but we do have actually, pictures, he has purchased the fencing, and we'll be working on it. I'll be on him, and he'll be getting that done.
Okay, so you're,
She's
you're-
definitely on it.
Exactly.
so you're in the process, and how long do you think it's gonna take you to get it?
Well, again, I'll have the fence up by this weekend, but the gate to actually the trailer won't be visible from the front. Again, it's a lead time because I have to have the gates, made. So, like I said, they told me 3 to 4 weeks out, I believe.
Okay. Mr. Lloyd?
Yeah. So, you'd mentioned that you'd already got the fencing ordered and so forth. Have you ordered the gates already?
No, not yet. I have the fencing there on property. I got the pictures of the fence, but the gates, I wasn't sure if I was gonna do two 10-foot wide gates or one 12-foot gate. So I'm
Right.
kind of make a decision on that because the gates are pretty expensive. They're like $1,000 a piece for the 10-foot gates, aluminum reinforced. So.
Okay. I just, that's a tough decision mobility-wise, whether you want to have to move a 12-foot or two gates. Generally, if we were to make a finding, we generally runs about 30 days, so that was why I was asking about the gates.
Oh, okay.
Okay, because that would be a concern that we might have. But you definitely could work with Mr. Allen on that.
All right, and if it goes past, you can come in and, should you get a finding or a fine, that you can come in and let us know what your progress is. We'll go
Okay.
from there.
Okay.
Any other questions? There being none, is there anyone else in the pool that would like to address this issue? There being none, thank you.
Thank you.
Call for a motion.
I'll make a motion.
You make a
Yeah.
motion. Mr. Lloyd?
Based on the testimony of Code Compliance Officer Doug Allen and Mr. Rodney and Ms. Amanda Thomas presented to the board at this hearing and the documented evidence received by the board, I make a motion that the board find Mr. Rodney Thomas and Ms. Amanda Thomas in case number 18-3726 to be guilty of violating section 12-859 subsection 3 of the city code and give the respondents until December 12th, 2018, to come in compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $25 per day shall begin to accrue on the day following the compliance date and continue to accrue until the date the violator provides the city with evidence that the property has been brought into compliance.
Is there a second?
I'll second that.
Second by Mr. Newkirk. Any discussion? I'll call for the vote. All in favor?
Aye.
Opposed? Nay? No nays. Thank you. Next. Oh, do you understand what's going on? You were found guilty of the violation. A fine has been assessed at $25 per day for each day that it's out of compliance. You have until December 12th to come into compliance. And prior to you sitting down, I, said that if you got your order in and things like that, and you need to come back to the December meeting, December 12th, and let us know.
Okay, now, the fines will not start till after December 12th?
That's correct.
Okay, okay.
Okay?
All right, thank you.
Thank you.
The next case will be case number 183880, City versus Lila Now Sahab, for the property located at 12402 Pampas Place. The case is before the board based on the alleged section of 12859, subsection 3, RVs, boats, and trailers non-conforming, and 12861E6, fences appearance. Case will be prosecuted by Director Tom Baroni. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Tom Baroni, Code Compliance. This case this evening originated proactively on September 7th, 2018. My inspection that day noted a utility trailer in the driveway unscreened, a Chevy Suburban with no tag, a wood fence in the side yard in disrepair, and the wood trim on the second floor of the exterior windows lacking protective sealant. Left 4 door hangers that morning with a reinspection of September 19th, 2018. My inspection on the 19th of September noted that the Chevy Suburban had a vehicle tag. However, the utility trailer, the wood fence, and the wood trim molding remained out of compliance. Therefore, a notice of violation was prepared with the compliance date of October 5th, 2018. My inspection on October 19th, 2018 noted that the trailer was still unscreened in the driveway, the fence remained out of compliance, but the wood trim was painted. At this time, I would like to submit photographic evidence of the violations. Exhibit number 1 noted the wood fence damaged, and exhibit number 2 shows the utility trailer stored in the driveway unscreened from view.
Board will accept.
As of this date, the wood fence and the unscreened trailer are now in compliance. Therefore, I'd like to submit an affidavit of compliance.
Board will accept.
And the city's just looking for a finding.
Are there any questions of Director Baroni?
Thank you.
Thank you. Is there any other person that wishes to speak on this? There being none? Oh. No?
Unnecessary. Unnecessary, thank you.
Okay, thank you. Call for a motion? Mr. Snelling.
Based on the testimony of Co-Director Baroni presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find, I apologize for the pronunciation, Liha Nur Salhab, in case number 18-3880 to be guilty of violating section 12-859 subsection 3 of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Second?
I second.
Second by Mr. Westfall.
May I ask a question or ask the
Yeah.
motion maker to amend his motion to include section 12-861, parent E, parent 6,
Oh,
offenses
yes.
of the code as part of the motion.
Please.
You want me to read it over again? or-
You can just add it.
Amend the motion.
Yeah, I would like to add the violation to section 12-861 subsection E subsection 6 to the violation.
And I second. Thank you. Any discussion, any further discussion? All in favor? Aye. Opposed? Nay? No nays. Next case, please.
The next case will be,
Do you want, yeah, you're free to leave. You understand you were,
I'm just I appreciate it, thank you very much.
thank you.
Thank you so much. Have a good night.
the next case will be repeat case number 18-3917, City versus Syed Jafar Bahabani for the property located at 7602 Willow Park Drive. Case is before the board based on alleged violation of section 10(3)B, sanitation grass weeds. Case will be prosecuted this evening by Officer Jose Silva. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, board members. Jose Silva, Code Compliance Officer. This is a notice of repeat violation. This case was presented to the board on July 11, 2018, MCEB 18-2291. That time, the board found that a violation did occur at the property, but the property was brought into compliance prior to the MCEB hearing. On September 10th, 2018, my inspection at the time noted that the yard grass of the residence was again overgrown. This time, I issued a door hanger at the residence with a compliance date of September 13th, 2018. My inspection on September 13th, 2018 revealed there was no change, so I issued a notice of a repeat violation at the residence. The residence was unoccupied, so I posted the notice at the home as well as City Hall, also mailed copies, both certified and regular mail, to the address and the registered owner. On September 19th, 2018, I received a phone messages from an individual named Assad who said he was a realtor selling the residence. He requested to have the weekend of the 22nd to the 23rd to have the property mowed, which I told him it would go ahead and get the property mowed. On the 24th of September, I conducted an inspection at the residence. The grass was still not mowed and it was overgrown. This time, I'd like to submit photographs taken of me of October 17th, along with the copy of the MCEB order of the ruling on 18/22/91 at that time.
Board will accept.
As of October 30th, the grass at the residence has been cut, and I would like to submit an affidavit of compliance.
Board will accept.
Currently, the residence was out of compliance from the 24th of September to the 30th of October, which was 37 days out of compliance. And there is a representative for the homeowner here tonight.
Are there any questions for Officer Silva? Mr. Lloyd?
We're using the 24th as the date because
As
of
a-
the
as a-
phone call you had with the Realtor.
The 19th was the phone call that I had.
So
The
notice of-
24th is the 10 days
From
of-
when you served
from
the notice of
service.
repeat. Okay, that's what I needed to get straight. Thanks.
Yes, sir.
And have you been by there since the 30th?
Yes, sir. I drive by there every day, and it's being maintained.
Okay.
Any other questions of Mr. Silva? Officer?
Thank you, sir.
The respondent, please come up. Name and address, please.
My name is Amina Sheikh, and I'm representing the.
Can you move the mic down just a tad?
Okay. I'm Amina Sheikh, and I'm assistant to Asad Sheikh, who's the realtor, who has exclusive right to sell this property on record. Did you want the address too?
Your address.
My address, 8101 Kendallwick Court, Tampa, Florida,
Thank you.
33647. It has been very difficult to communicate with the owner. He's out of the country, and we wanted to do this earlier so that the property would be in compliance, but we could not get the funds soon enough. And we didn't want to be in a position where we were not paid for the services. So when we did get the funds, we went ahead and got the grass cut. Now, I would like to please know that if there was a repeat violation again, because he's very difficult in sending in the funds, so I'm assuming that this might happen again. So I would like to communicate to him that if he were to do that again and the grass was unkempt, what the consequence of that would be.
You want to communicate that to him, yes.
Yes, because, we want to get the property sold, but I don't think he understands what's going on,
His time is not your
So
time.
either we give up, we just say, okay, we cannot work with you, or either way, we want a closing to it.
Are you under contract with him as his seller agent?
I'm not, Assad Sheikh is, and I'm assisting him. I'm his assistant.
Okay.
Yes,
So you have a commitment connection, so that's what I was asking.
yes, yes. He knows that we are in a group chat together. I'm on the group chat with him, the owner. Yes.
Okay, any other questions? Mr. Napke?
Is there currently a contract on the house? Has it been an offer and
No.
accepted? So it's, okay.
There is an offer. I believe it must have expired, but because the property is not in a proper shape, it's way below the asking price, and I think he declined it, so.
Okay,
Yeah.
thank you.
I got a question.
Mr. Lloyd?
And Code Enforcement Member Jose Silva testified that it's been being mowed. Are you all the ones responsible for keeping it mowed?
Yes.
You all have been maintaining it?
Well, I don't know what you mean by responsible, because I'm not going to do it out of my pocket, so if he doesn't pay me to do it, if he doesn't PayPal me the money, then I'm not going to upkeep it.
Well, as of right now, you said it's compliant, so
Yes.
it's because of your efforts that
Yes.
it's mowed. Thank you.
Yes.
Okay.
Any other questions? There being none, thank you.
Okay.
A call for a motion.
I'll make a motion.
Mr. Lloyd?
Based on the testimony of Code Compliance Officer Jose Silva and Ms. Sheikh presented to the board at this hearing and the documented evidence received by the board, I make a motion that the board find Sahid Jafari Bahabani in case number 18-3917 to be guilty of a repeat violation of Section 10-3B of the City Code and assess a fine in the amount of $370 against the respondent for the days that the repeat violation has existed prior to this hearing, and in addition, assess a daily fine of $30 per day, which shall continue to accrue that the date the violator provides the city with evidence that the property has been brought into compliance, but the property has been brought into compliance as of this date. Question for you. Would the $30 automatically kick in, or do I need to strike that last sentence?
I believe since it's in compliance, I don't think there's a daily fine that can be assessed at this
In the
time.
future.
It's just your,
Okay, so I'll reread it. Okay. Based on the testimony of Code Compliance Officer Jose Silva and Ms. Sheikh presented to the board at this hearing and the documented evidence received by the board, I make a motion that the board find Sahid Jafari Bahabani in case number 18-3917 of the City Code and assess a fine in the amount of $370 against the respondent for the days that the repeat violation has existed prior to this hearing. And since the property was brought into compliance, no fine shall continue to accrue.
second.
Second by Mr. Napke. Discussion? I think it was a fine motion. All in favor?
Aye.
Opposed? No nays. Can you come up again, please? Okay, just for clarity, there is a $370 lump sum fine for the days that he was not compliant.
Okay.
And because it's compliant as of today's date, no further fine shall be accruing.
Okay. Is there any way we can appeal it? The
The
fine? Yes.
I would,
Yes, you can file an appeal. It would be to the circuit court, and you have 30 days in which to file an appeal.
Okay.
And that's from the date that the order is entered. This order will be sent to, we'll make sure we have your address and that we have a good address wherever, for Mr. Babahani, so that
Okay.
he gets a copy of it as well. Because he's the respondent, it's up to him to make the decision
Right.
whether to appeal this, but you wanted to send him a message, this is it.
Yes.
So,
Well, I didn't want to, but I just wanted to find out what the consequences were. My job is just to communicate that with him.
okay, do we have an address for, we have a good address for Mr. Babahani?
I don't,
7602 Willow Park. And he's
yeah,
not
that's the home address, yeah. Doesn't
He,
matter.
and he is there,
No, he's not there. He's out of the country. I'm collecting his mail for him.
okay, so you don't have an address for him either?
We may, I can get back to you on that, but,
That would be good, because he's the one who really needs to get this.
okay, okay, all right, thank you.
So on that, you can get back with the city clerk to get her that information, and the sooner the better.
Okay,
And if you can keep it in compliance, this won't come forward again, but,
we're going to try.
Yeah.
Thank you.
okay, thank you.
And if we could get an address for you too, because otherwise, just to be sending it to Willow Park and you collecting the mail, nobody opens it.
Do you want my address right now?
Yes, please.
Mr. Chair, if I may,
Sure.
on this one, yeah, I would recommend we send an order to the address that's with the property appraiser. Yeah, no guarantee that the actual out-of-the-country address is going to come in. You'll make your best efforts to get that. But yeah, just keep in a courtesy to Ms. Sheik, I believe is her name, is fine. But remember, she's only a representative of the agent of selling it,
Right.
not an actual agent of the property owner. So that's going to be important that this, we make every effort to get this order to the property owner so that, you know, 'cause especially if there's been an indication of appeal, because it'll be for the property owner to appeal.
City Attorney, Mr. Shown, if you would come up to the mic when you are speaking, because I watched it back last month, and we can barely hear you, so, okay?
All right,
Thank you.
We're gonna move on in just 1 second. We're just seeing if anyone else is here for hearings.
If I may, Chair, Mr. Shaw will close that door so we don't hear the hallway. Thanks.
No, he'll get it.
Oh, does it? Thanks. Thank you.
Anybody have, Dunedin? Dunedin. Yeah. Anything going on in Dunedin?
Is it a lien?
Yeah.
Code violation.
I know, I have the case, but I haven't set it for the court.
Okay. So the inspector has a case against your property, but it's not his, it's not his. No. Okay, all right. Sorry for that.
Set it up yet.
We're still working on
Go there, sir.
That's good.
Good.
That's progress.
Yeah, he's eager to get it resolved.
That's good. That's good.
We're going to take the lien reductions now, and we'll take those in order. So, Tom will go ahead and present.
That was pretty funny. Good evening, Tom Baroni, Code Compliance Director. At this time, I would like to introduce this lien reduction petition request in case number 101146, City versus Joaquim Hernando Cadava. Property located at 13016 Sanctuary Cove Drive, apartment 201, that has a lien amount of $12,600. This case was heard at the August 11, 2010 MCEB hearing, where the respondent was found in violation for failure to obtain an annual rental permit. A $200 a day fine would accrue starting on September 8th, 2010. The fine continued to accrue until the November 10th, 2010 MCB hearing meeting, when it was recommended by legal counsel to cap the fine at $12,600, based on Florida Chapter 162. Trying to be consistent with a case that I presented back on September 12th of this year at the Code Board hearing, my recommendation then was to keep a lien at $1,000. And tonight, my recommendation is to reduce the lien from $12,600 to $1,000. In this case, there was 10 inspections by the city, which amounted up to $430. So my recommendation this evening is $1,000.
Are
The
there any questions?
petitioner is here.
Okay. All right. Joaquin,
Good evening.
good evening.
My name is Chantel Conklin, and the address is 130616 Sanctuary Cove Drive, Unit 201. My husband and I purchased this property in June 2015 at a tax deed auction, and we were not aware that there was a lien on the property when we purchased it. Soon after we purchased it, we received a notice from the Temple Terrace Fire Department advising us to apply for a rental permit if the condo was going to be rented. So we complied and had our first inspection in October 2015. We've diligently paid our rental permit and have had no violations noted during each annual inspection. This past August, we received a letter from the city of Temple Terrace informing us of your intent to foreclose on the condo for this unpaid code lien. I immediately contacted Ms. Garcia, who informed me that the previous owner had failed to obtain and pay for his annual rental permit and daily fines of $200 for a total of $12,600 was due. Again, like I said, when we purchased this condo at a tax deed, we were unaware that there was a tax lien on it. We would like to ask the board to please consider a request for a lien reduction. Thank you very much.
Thank you. Are there any questions? Go ahead. Mr. Napke.
Did you do any type of title search?
I did not.
Your attorney, and you mentioned in here that you
Yeah,
had an attorney.
our attorney misled us. He told us that, any IRS liens, water liens, municipal liens would not convey with the property. So no title search was done.
Have you tried to contact the former owner
No.
about leaving this hanging for you guys?
No, my understanding is the former owner owned like 4 units in that complex, and he did not pay any of the rental permits. And, I mean, we've owned the property since 2015. I don't know where this gentleman is.
Since that time, I assume it's been rented?
Mm-hmm,
So y'all have gotten income off of it since then?
mm-hmm.
Okay. Thank you. That's my
Mr. Snellen.
I had a question for Director Barone. That's a quick one. If I understood you correctly, you said the $1,000 amount that you came up with was based on, to be consistent with a previous,
Yeah, I presented a case back in September of this year, annual fire department rental permit, and I reduced that. I didn't reduce the fine, actually it was $1,000, and I didn't reduce it at all. I kept it at $1,000.
and that's the basis for your $1,000?
Yeah, I want to be consistent, and also too, it's a health and safety issue. When a homeowner or the landlord does not get an application or failed to get the permit, because then there is no fire inspection done on that apartment. So it is a health and safety issue.
Okay, thank you.
Mr. Lloyd.
Yeah. Tom, this goes back to 2010.
10, right.
Has there been a change in the capping the amounts consistent when we assess a fine on rental properties?
Well, it has changed.
And could you enlighten us as to what your recollection of that change is?
Well, and back in 2010, 2 months after that code board hearing, Tim, the city attorney at that time, recommended at the November hearing to cap that fine because it was $200 per day. So that's why it was risen up to $12,600. Normally, we just cap it at $1,000.
And we've done it previously with other
Yes,
cases?
yes.
Okay.
Any other questions? Thank you.
Thank you.
Call for a motion.
I'll go for it.
Mr. Lloyd. Thank you.
This one we don't have, so I'll freestyle it here. No, I make a motion to the board and city council in lien reduction case number 10-1146, City versus Joaquin Hernando Cadavid, that we reduce the lien amount to $1,000 as recommended by the city and consistent with the testimony of Code Enforcement Officer Barone as to other cases.
Is there a second? Second by Mr. Newkirk. Any discussion? All in favor?
Aye.
Opposed? Nay? No nays. The lien on this, the finding is that the lien on this property has been reduced to $1,000. And it's, I will present it at the December meeting of the city council. And whether or not they approve it, then if you want to be at that meeting, you can represent yourself at that meeting.
Okay.
If the fine is not paid within 30 days of the approval by the city council, the fine will return back to the full amount,
Okay.
okay?
And so will I be notified when this meeting will be?
Yes.
Okay. All right, thank
And
you.
I think it's going to be later on in the month, not at the first Tuesday, it'd be like the 18th or whatever it is, the third Tuesday.
I think she's checking now. Is it the third Tuesday in December?
We will let you know. We'll have to check the agenda schedule.
Okay.
I believe it is though, but they'll let you know.
All right, thank you.
Thank you. You're free to leave if you wish.
This is the second lien reduction request. Tom Barone, Code Compliance Director. Before I present this lien reduction petition, I'd like to inform you that this lien petition was presented to the Code Board back on March 14th of this year with a lien amount of $34,425. The board voted to lower the lien to $16,605 by a 4-3 vote. However, the amount was based on the matrix calculator that we use only to find out that in the next month, in April, the city was no longer going to use the calculator. This petition was never presented to council, and the petitioner advised me that he was not able to pay the $16,000 lien reduction. I myself have a hard time in finding the owner $33,150 for a collapsed tree branch that fell from the neighbor's yard. However, I do believe the homeowner should be held accountable for this slow compliance. So I just want to make the board aware that I had presented this case back in March of this year. And I also made a recommendation to the owner's son that since he can't afford the $16,000, that he should not proceed forward with it, because once I present it to council, they make a recommendation, he has 30 days to pay this.
So I figured I gave him a little advice and said, if you don't need to proceed with this, then hold off moving forward with this. So that's why I'm going to present it again tonight. So are there any questions for that before I start? Because I'd like to resolve, if there's any questions, I'd rather resolve that first.
Mr. Lloyd?
And you might speak to this, I'm reading the narrative here about the property was in foreclosure, then transferred around 2004. Are you going, would all that be covered in this? Was this the owner of record back when this fine started accruing?
Yes. The 11 years that I've been here, Mrs. Anderson has been the owner of the property of record.
Okay, because I see lots of case numbers presented here. And then I
There's
see-
3 cases tonight that I'm going to present.
Okay, and then the date of ownership of property transfer indicates this was a foreclosed property.
I don't recall that, to be honest with you, but maybe you could ask the petitioner tonight.
Okay.
But I just want to make the board aware that why I'm here tonight to present
Cool.
this again.
And what led me to that was then when I saw the $20.99 outstanding utility bill.
Right.
So that kind of made me go caution to, maybe it was foreclosed.
Right.
Okay.
Thank you. Anyone else?
Okay. At this time, I would like to introduce a lien reduction petition in case number 102154, 16-0257, and 171378, City versus Natalie Anderson, who is the current owner of the property located at 105 Deer Park Avenue, with a lien amount of totaling $34,375. Petitioner is requesting to lower the lien to $500. The city costs in all 3 cases are $1,925. In the first case, 102154, this was an unclean swimming pool contents, which was a repeat violation that accrued a fine of $700. In the second case, 16-0257, there was 3 violations that I presented to the code board that evening, where the respondent was found in violation and was given $75 a day fine. 2 of the violations were taken care of within the first month. So there was a permit, a fence, and the collapsed tree branch. That was the 3 violations that I presented. Within the month, he took down the fence, so it no longer required a permit. So 2 of the violations came into compliance. However, the tree branch remained out of compliance and accrued a fine of $33,150. In the third case, 17-1378, this was a pod container violation that accrued a fine of $525. My recommendation to the board this evening is to reduce the lien from $34,425 to $1,900. How I came up to this conclusion was by not lowering the lien to the repeat pool violation, and because it was a health and safety issue, and the pod case, because I felt as though it's a small amount of a lien. So, however, I lowered the collapsed tree branch case to a reasonable amount of $675. Adding the $525, the $675, and the $700, that totals $1,900. So it's compatible with the city cost of $1,925. So my recommendation to the board this evening is $1,900.
Are there any questions?
I do have, I do have a picture of the collapsed tree branch just to show you what kind of violation it was. If you need to see it, you would like to see it?
Board will, pardon? You want it? Board will accept it.
Can I ask him a question while he's reviewing that?
Mr. Lloyd?
You still have more to say, Tom, or can I ask you a question?
Let me just finish up, sir.
Absolutely.
Thank you, sir. Just, I'm sure the question is, why does he want to proceed? Well, when he first received a letter from the city stating that he owed $34,000 in liens, that's when we first initially presented the case. And then I told him to sit on it and just wait until maybe you're going to sell the house or whatever. He received a second letter from the city, the demand letter, the city attorney sent out. So he's now thinking that the property is gonna go into foreclosure. So that's why he stepped up and said, I need to resolve this. So that's why he's here tonight. So at this time, I'm completed.
Mr. Lloyd?
You testified to the amount, the calculations is $1,900. That amount is separate, and again, this is something that I think we need to work on. I'll make a motion of the petition here.
Okay.
Is that 1,900 is not inclusive of the 1,923 that's listed on the petition, is that correct?
That's correct.
Okay. So, and that amount consists of, that amount was calculated by how? Where do we come up with the 1923 from?
I guess that's the water account?
No, it's the,
City cost.
Oh, the city cost.
so in essence, you're wanting it to vacate the city costs and just reduce it to the amount of the fines?
That's correct. That's correct. I could either went 1925, but since one is 1,900 and the other one's 1925, I'm just rounding it off to $1,900.
Any other questions? Thank you.
Thank you.
Respondent. Mr. Hernandez?
Yes. Vincent Hernandez, 105 Deer Park Avenue. Property is owned by Natalie Anderson, my mom, and I've been there since 2004, as stated. It wasn't a foreclosed home, it was bought from the previous owner. Since then, my mom has transferred all houses and all utilities and everything from all the property that she does own, our siblings and stuff like that, because it's easier to control that way. Therefore, we pay her, she pays her bills on time, she's unlike myself, so I don't. That's why I incur extra fees. As well as the violation that we're discussing today, the reason Director Baroni did instruct me, to sit on it and, maybe see how we can work it out, but it made me nervous, and it's a big weight on me. I mean, to be hit with 34,000, and I wasn't unaware of it. This was from 2016. Had I been aware of it, there's no way I would have allowed it to get that high, especially for a tree branch. It was not my branch, it's my neighbor's, but he since went to a nursing home. I try to help the guy out. It's just, he's a dementia, everything, I'm not gonna blame him, but, it's a long history. I've been there 15 years, so, yeah, I wanna take care of this and get it off from, cause it's a huge impact on me. It's like my daughter, from breast cancer to now stage 4, it's like a hitch. It's huge, the weight on my shoulders, there's too much to deal with right now, and I'd like to take care of it. However, being it takes 30, I only have 30 days to do it, 30,000, 16,000, it's all the same to me. Not that it's the same amount, but it's all the same to me. There's no way I can come up with that kind of money for 30 days. I also don't agree that it should incur that long. Had I known, because I don't remember any kind of notifications in that time. I thought everything was okay. And I was burning I had an old barbecue, I was burning some of the wood little by little to get rid of it. I didn't have all the problem. This is how I got 3rd degree on my whole arm from that, from oil spilling on it, so I'll never do that again. So yeah, whatever the amount you guys agree upon, I mean, that's what I have to agree upon. Hopefully you have some consideration for my situation and where I'd be able to pay it within 30 days.
Okay. Just for the record, as you learned that a branch from your neighbor's tree becomes
My
yours.
responsibility. It's my responsibility.
Yeah, it is, and
yeah.
it is for all of us.
Yes.
So it's just, I'm kind of saying this to, if anybody's,
No, you're correct. I
Watching
just
that.
mentioned because there's been a number of times that things have come around, and I've hired people to trim down his trees because otherwise they keep falling on my thing, and I've had power outages because of it. So I've incurred the fees on it, but I've never bothered him about it.
all right, I guess it's the shade that we get from the tree that makes us enjoy it, right? And then if
Yeah.
it falls on you, it's yours.
Yeah, it's fine.
Okay. Any other questions? Mr. Lloyd?
Mr. Hernandez, have you had dialogue with Mr. Barone about
Yes.
the reduction amount in your petition and so forth, and what he proposed tonight?
Yes.
To this board? Okay. Is that something attainable for you?
It's very hard nowadays, for me. It's a violation. I need to pay the fine. I just want it behind me, but I do want to be able to take care of it, so the amount would have to do a lot with that.
Well, and not to supersede Chairman Schmidt, but this does go to city council. We just make a recommendation.
Right.
And you are allowed to state your case, and the city council is the ultimate, they can send it back to us saying reconsider. So just know that, and we appreciate you being here today, as well as, I'm sure you were planning on being here in the past. So
Yes.
that might be something that, whatever we find, you might want to consider going to the city council meeting.
And, excuse me, when are those hearings
Well,
held?
we got to do a finding
Once you
first.
do, okay.
Yeah.
Yeah,
I kind
it's-
of got that cart
it's-
ahead of the horse.
Yeah, it's normally between 6 and 6:30 that we get in there. Might be up closer to 7, but you'll be notified of when it is.
Right.
We're not quite sure tonight for sure, but I think it's going to be around the 18th, the middle of the month. Any other questions? There being none? Thank you, Mr. Hernandez. Call for a motion.
I'll make the motion, unless
Thank you,
somebody else has a motion they'd like to make.
You're the winner.
Okay. I make a motion that in lien reduction case 10-2154, 16-0257, and 17-1378, City versus Natalie Anderson, and the testimony from Code Director Tom Barone and Mr. Hernandez, that the lien is reduced to $1,922.99, and the recommendation be made to City Council for that amount.
Is there a second? Second by Mr. Nopke. Any discussion?
Yeah, yeah. I agree with vacating the city costs that are listed at this time, because those have been subject to review. But I do agree with all the violation amounts. And then the $22.99 is for the outstanding utility lien that is on the property. So I'd like to get that cleared up as well, and that's why it went over the $1,900 that Mr. Barone recommended.
Okay.
I'll second
It's
He
already
already,
been
yeah, he
seconded.
got it.
But you can do it.
And I'm open to anybody else that has another opinion on
Any other
that, on
questions?
the amount.
Any other comments? Call for a motion? I
Did
mean,
you have a comment, Mr. Sullivan?
No, not really. I'm glad you stepped forward to give us a recommendation, but you did say that you were,
closer to the mic.
sorry, that you made some comment about removing the city costs from the equation, and I didn't quite follow what you.
Well, I just wanted to read in the record what I asked Mr. Barone about the amount that's on the lien reduction here, the 1923.42, so that other cases had come before us, and that I was giving weight to the fines that were accrued for the violations, and that this is subject and has been subject of discussion and how those amounts are calculated. So I was not going to hold the respondent to that amount there, because then it would have been $3,800.
Right.
So that's why I said, let's just go with the city's recommendation, which I'm comfortable with, because it's the violation fines for the fines of the violation.
Okay, thank you.
Any other comments? All in favor?
Aye.
Opposed? No nays. So, Mr. Hernandez, what has come before us tonight before you tonight is a fine, a lien reduction to $1,922.99, and This will be brought before the council at a December meeting. I believe it's going to be the second meeting. And you will be notified of that. You can come and support us or question us, whichever way you want to do it, and explain yourself to the council. However, whatever the council decides, that fine, if they go with the reduction, it would be reduced to $1,922.99 and would need to be paid within 30 days, or the lien would go back to the original amount of $34,375.
Right.
Okay?
I overheard something about a past due utility bill. I mean, at this amount, I'm not complaining about it. I believe it was $22, but I was unaware that I've had
Yeah,
something
It's
back
been
there.
carried since the hearing, the last hearing, that when we had, when you came before us before,
Uh-huh.
that was on there. As
And
a water bill.
they'll be able to, the city will be able to tell you if there's indeed that amount on there for you, but based off this petition that I'm gathering as the evidence, is there still, and it could have been well before you moved back to the property, that maybe the city was just carrying that balance forward. I don't know.
So it's been many years.
It could be.
Could be.
I don't know. But that's on.
Because I've been there
that's on
since
the petition.
2004.
Yeah, so
So-
you just have to check with the city
Oh,
and
I
see.
don't know. Okay.
If it has been taken care of, you find it has been taken care of, then you need to notify Kristen about, the city clerk about it.
It's not an issue. It's only $22, correct? So, I mean,
99
but that's
cents.
included now, this way it's
Yeah.
all corrected at
Yeah.
that point, right?
Yeah.
Yeah, at this point. Thank you.
Thank you.
Mr. Chairman,
Yes.
just a point of discussion on lien reductions. And maybe this is for the city attorney. We say 30 days. Has there ever been a case that the city has granted someone longer than 30 days on a lien reduction that we're aware of?
Yeah, I think they,
But that was a councilman's, that was part of their motion to, in agreement.
yes, it was presented to them to.
Mr.
and
Scholl?
requested-
Please.
The reason I'm asking is the timing of the year.
I think last month, or the last council meeting, Councilman Ross had made that, asked that that be part of the motion, that the person be given more than 30 days in which to pay it.
Okay.
So it can happen at the council meeting. You can make that as part of your recommendation as well, if that's what you would like to do on any of these. It would just go up to council as part of the recommendation, along with the amount of the lien. Or when the petitioner gets up in front of council, if they show up, they can certainly ask council to consider that when they consider their motion, to accept your recommendation or not accept your recommendation.
So because my motion did not have a date time in it, that means do we have to do another motion, or can that be part of what is stipulated in the record presented to the council?
Well,
And I don't know if that's maybe Ms. Mueller or...
well, I want to address it first, but I think that the councilmen watched this meeting, so to whatever benefit it is for them. And they did make the recommendation last month. It wasn't requested by me. I gave my presentation, and that was on information that they determined. And so that would probably happen again.
Okay.
I
mean,
would
and the
guess.
reason I posed the question is December, we're talking December, January. That can be a difficult time financially for individuals. So, I did not know that we could include that
If-
in our recommendation.
If you would like to make that part of your recommendation, then I would simply make a second motion
Okay.
now. And then when Mr. Schmidt presents the recommendation to council at whatever meeting it's set for, he can include that as part of the board's recommendation.
Or,
Or you wait till you let it go now, and the petitioner can get up and ask council for extra time to pay it off, and then it's left totally up to them.
going to ask Chairman Schmidt, since he's the one presenting them, which course of action he would recommend.
Well, I kind of like the second one,
Okay,
but because the petitioner's not here.
okay. And I would agree with that, but then maybe we can,
I have
in
another
the
question.
future, though,
Yeah, I have
consider
a-
that.
That's a good point, but we're making a decision that the city might not agree with, and then they turn the motion down because we're making a decision. My question is, that's following on the same thought, is that when the petitioner comes into the council meeting and whether or not he says he would like a payment plan, I would imagine that the city would be able, if he comes in and says it's a hardship, being he's agreed to pay it, if there is such a thing as the city working with him on a payment plan.
He can always come in and ask for whatever it is he wants. It's up to council then to make the decision. If he wants to ask for a payment plan, he certainly can ask for that. It's up to them to make the decision as to whether to grant it to him. And I agree with the suggestion at this, only because he's left.
Right.
That you wait, that you not do the motion, because if he were here, he might ask for 60 days, he may ask for
Yeah.
90 days,
Right.
and he's not here to make that particular request. So-
Or $34,000 fine that's over 35 years. you
Yeah.
know.
I
mean, that-
I like the clarity and the information that we received, that we could possibly make that recommendation, because we are making a recommendation to city council, and, hopefully they value our recommendation sometimes. So I think moving forward, that would be something we'd want to consider, is including the time component to it, because some of these are, certain cases. Mr. Miller, did you have something
Well, I
to
was
add?
just going to mention if, since I had drafted up some proposed scripts and I did not include the fine reduction, if the board would so like me to take a stab at that too.
Yeah,
please.
most definitely.
Good idea.
Yeah, we're going to see a lot more of these as the economy keeps going.
I agree.
Thank you for entertaining my discussion.
Mr. Chair,
Yes.
can I continue on this for
Sure.
just a moment? Could you, sir, based upon your experience and Ms. Shashan's experience, possibly give some payment term guidelines? Like if the lien is $5,000 that we recommend to city council, the maximum number of months or years, kind of a policy statement from experience. Otherwise, we'll have, what I fear we'll have is, well, I can only pay $10 a month. Somebody else will say, well, I can pay $25 a month. We will have inconsistent amounts of recommendations based upon possibly the same amount of money.
I hear you on that, and that starts to border on that matrix. I think we should take every case on a case-by-case basis. They're going to give testimony. I think if we had a flat fee structure, I think it demeans the merit of the testimony of the petitioner and the case and the city. I don't know, that's just my opinion on that. At first glance, I'm open to discussion further, but for tonight, that would be my first take on it.
So you're saying you don't want another matrix, is that what I'm hearing?
That's true.
I think we should give full merit to the petitioner's testimony and take it on a case-by-case basis and give full merit to the recommendation of the code enforcement officers that work with them, because they're the ones that know how quick they got the property turned around. They're the ones that can testify to how many complaints they received when they're out in the field. So that, to me, would be more of where I'd want the merit to be than on a pay structure. And that's just my first 30-second thought on it.
I got 31.
Okay.
I think what I would like to do is take this discussion and take it back to the city manager and see where the city lands on it. As part of they're getting late fees for water bills and and other things that, how did they deal with that? So if Kristen, maybe I guess it's you, if you can take something to him, to the city manager, and let them weed through it in a couple of days and get back to us and tell us what they would like us to do, because we may be, again, getting out in the wilderness on this, and it may be totally against what the city is agreeable to,
I'll follow up with the manager.
okay? I'm sorry, I maybe got out of line.
Thanks, Tom.
Thank you. Okay, are we ready to roll?
Okay.
Let's go. Thanks.
Next case, 183772, City versus Fadi and Herbawi and Candy Almagith for the property located at 7932 Terrace Ridge Drive. Case is before the board based on alleged violation of Section 810213B, exterior walls maintained in good repair, and Section 810213C, roofs maintained in good repair. Case will be prosecuted this evening by Officer Jose Silva. City has evidence that the notice of violation and notice of hearing were properly served.
What's the location?
Yeah, that's what I got.
What's the case number?
3772.
This is Lori's case. Lori's case.
Sorry about that.
That's okay. Good evening, board members. This case originated proactively on August the 29th, 2018 by Officer Jose Silva. Officer Silva's inspection revealed overgrown yard grass, exterior wall, and fascia board also were stained. At that time, Officer Silva left a door hanger with a compliance date of September the 3rd, 2018. Officer Silva's reinspection on September the 14th, 2018 revealed the overgrown grass was mowed. However, the stained wall and the fascia board remained out of compliance. This case was transferred to me on that same day, so a notice of violation was prepared by me on the 14th of September with the compliance date of September the 29th, 2018. The home was unoccupied, so I posted the notice at the home as well as City Hall. I also requested a copy to be sent both certified and first-class mail. My inspection on October the 11th, 2018 revealed no change. At this time, I would like to submit photographic evidence of the violation taken by me on October the 11th, 2018. Exhibit number 1, stained exterior sidewalls. Exhibit number 2, stained fascia board.
Board will accept.
As of today's date, the inspection noted staining on exterior wall and the fascia boards are now in compliance. I would like to submit an affidavit of compliance.
Board will accept. Are there any questions?
I'm just looking for a finding, sir. Board members.
The respondent in this case is not present.
No, sir.
There are no other questions. I call for a motion. Let's get some weight over on this side.
All right, I'll do another one of these. Based on the testimony of Code Officer Smith, presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Fadi N. Herbawi and Candy Almig Thay, that's my best shot there, in case number 18-3772 to be guilty of violating sections 8-102 subsection 13 subsection B and 8-102 subsection 13 subsection C of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Motion by Mr. Snelling, second by
Second.
Mr. Newkirk. Any discussion? All in favor? Aye. Opposed, nay? No nays.
Next case. Case number 183833, City versus Duality Nature, Inc., for the property located at 328 South River Hills Drive. Case is before the board based on alleged violation of Section 10-3B sanitation grass weeds and Section 828 A1 permits application required. Case will be prosecuted this evening by Officer Jose Silva. City is evident that the notice of violation and notice of hearing were properly served.
Good evening, board members. Jose Silva, Co-Compliance Officer. This case originated proactively on September 4th, 2018. During my inspection, I noted the yard grass was overgrown and the residence was recently stuccoed without a permit. This time I notified community development and a stop work order was issued and posted at the residence. On September 12th, I re-inspected the residence and noted the grass was partially cut and no permit was obtained for the stucco work. Since there was no change, I issued a notice of violation with a compliance date of September 27, 2018. The home was unoccupied, so I posted the notice at the home as well as City Hall, also mailed copies, both certified and regular mail, to the registered owner. An inspection on October 11, 2018 revealed no change. The yard grass was still overgrown and no permit was obtained for the exterior stucco work. This time, I would like to submit photographic evidence of the violation taken by me on October 11, 2018. Exhibit number 1 is going to show the overgrown yard, and exhibit number 2 is going to show a copy of the stop work order.
Board will accept.
As of November 14th, I've checked with community development. A permit after the fact has been obtained for the stucco work, and the grass has been cut at the residence. So I'd like to submit an affidavit of compliance.
Board will accept.
I am requesting a finding.
Are there any questions?
The stucco work that you're looking at is going to be the blue. That house had actually the wood siding on it.
There being no questions, I call for a motion.
I'll wait down this side.
Okay, good.
All right.
Good. Mr. Plow, come on.
Based on the testimony of Code Compliance Officer Jose Silva, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Duality Nature, Inc. registered agent Leslie L. Rodriguez in case number 18-3833 to be guilty of violating sections 10-3 subsection B and section 8-28 subsection A subsection 1 of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Is there a second?
I second.
Second by Mr. Westfall. Any discussion? All in favor? Aye. Opposed? Nay? No nays. And the respondent was not present.
That's correct. I'm here for the next case, sir.
Okay, good.
That next case will be case number 183885, City versus Diplomat Property Manager LLC for the property located at 107 South Greenfield Avenue. Cases before the board based on alleged violation of Section 8102-14A, B, fences maintained in good repair, Section 8102-13C, roofs maintained in good repair, and Section 10-4B3, nuisance, any condition or use. Case will be prosecuted this evening by Officer Jose Silva. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Jose Silva, Code Compliance Officer. This case originated September 7th, 2018. During my inspection, I noted the overgrown yard grass, vines on the roof with gutter vegetation. The rear privacy fence along Sunnyside Drive was stained, and there was a nuisance condition in the side yard of a large oak tree that had a branch broken off, which was still lodged in the tree and hanging in the tree overhead. This time I issued door hangers with the compliance date of September 14th, 2018. On September 25th, 2018, I re-inspected the residence and noted that the yard grass was the only thing cut at the residence and completed. Since there was no change, I issued a notice of violation with a compliance date of October 10th, 2018. The home was not occupied, so I posted the notice at the home as well as City Hall. Also mailed copies both certified and regular mail to the address of the registered owner. An inspection on October 11th revealed no change. This time I would like to submit photographic evidence taken by me on October 11th. First photograph is going to be the stained privacy fence along Sunnyside Drive, the tree debris, vines on the roof, and gutter vegetation. And number 3 is going to be the nuisance condition in the side yard.
Board will accept.
As of this date, the property still remains out of compliance. And I have had no contact with the new owners to the property. And as some of you might remember with this address, this was previously on our liens list for the longest time.
Are there any questions of Mr. Silva?
I assume Arlene was a previous officer?
Excuse me?
You said Arlene's list,
This was on our liens list previously.
she was a previous code?
Sal,
our-
excuse me?
Our lien list.
It was on our liens list
Okay, I get
previously.
you. Okay. Yeah, okay, I understand.
And it came off when a new owner took over.
Okay.
Any other questions? The respondent is not present for this.
Respondent's not present, had no contact. It is being mowed and maintained, but the other conditions are still present.
Mr. Lloyd, go ahead.
Do we know, you said it was on the liens list, you know what the amount was that was on the liens list? And was it because, why it came off, was it for?
It came off because it was sold.
Okay. Change of ownership, do we know what the amount was on the lien?
Excuse me?
Do we know what the lien amount was?
It was a lot.
More than the value of the home?
Excuse me?
More than the value of the home?
I can't remember.
And then, moving on, any work being done on the inside or out, or is it just kind of just being?
It's just sitting there,
Just sitting there, okay.
just sitting there.
Okay, any other questions? Call for a motion.
I guess I'll say.
Mr. Napke.
Well,
You have-
actually, could I just make a comment on this? Keeping in mind that it seems like there's previous violations, but it was under a different owner.
Right.
And I think that, I just wanted to make sure that was noted as we had talked about that earlier. It's
Right.
That, we always talk about with the amount of the fine, whether it was that violator. So we have a different
Thank you.
violator, it looks like.
Based upon the testimony of Officer Silva presented, based upon testimony of Code Compliance Officer Silva presented to the board at this hearing and the documentary evidence received by the board, I make a motion. The board find Diplomat Property Manager, Shapiro, Fishman, and Gash, in case number 18-3885, to be guilty of violating sections 8-102, parent 14, parent A, parent B, 8-102, parent 13, parent C, and 10-4, parent B, parent 3 of the city code, and give the respondents until, is it
December 12th.
December 12th, to come in compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $30 per day shall begin to accrue the following on the December 13th, 2018, and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
Is there a second? It's easy, guys.
I'll second.
Second by Mr. Lloyd. Any discussion? All in favor? Aye. Opposed?
Nay.
One nay. Mr. Lloyd.
I just think the fine's too low. Yeah. I think the fine's too low for what needs to go on at this property. It's easily fixable, but that's just my opinion. Thank you for entertaining my discussion.
Well, you had a chance to bring it in to the vote.
I'm open,
No,
I'll
it's
make the
done.
motion to
No,
recall.
it's
too
done. It's
late.
done.
It's too
It's
late.
done? Okay.
Next case, please.
Our next case will be case number 183940, City versus Esther Elizabeth Foley for property located at 8712 Coral Don Court. Case is before the board based on alleged violation of Section 10(3)B sanitation grass weeds. Case will be prosecuted this evening by Officer Doug Allen. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening again, board members. Doug Allen, Code Compliance Officer. This case originated proactively by me on September 11th, 2018. My inspection on that date revealed overgrown conditions. I left a door hanger with a reinspection date of September 24th, 2018. My inspection on September 24th showed no change, so a notice of violation was prepared with a compliance date of October 1st, 2018. No one was at home, so I posted the notice at the home as well as at City Hall, and copies were mailed, both certified and regular mail, to the address. My reinspection on October 7th revealed no change, so a notice of hearing was prepared on October 18th, 2018, and the case was scheduled for the November Municipal Code Board meeting. At this time, I would like to submit photographic evidence of the violations taken by me on November 5th, 2018. Exhibit number 1 will show the overgrown conditions.
Board will accept.
I've had no contact with the property owner. The front and side yards have been mowed, but the overgrown backyard area has not been addressed. So the site at this time is still out of compliance, and I'm requesting a ruling.
Any questions? Mr. Allen? We all good? Thank you.
You're welcome, sir.
There being, the respondent is not present, and there being no others to speak, I call for a motion. Mr. Westfall?
Based on the testimony of Code Compliance Officer Douglas Allen, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Esther Elizabeth Foley, in case number 18-3940, to be guilty of violating sections. Microphone. Oh.
Thank you.
To be guilty of violating sections, Section 10-3, subsection B, of the city code, and give the respondents until December 12th of 2018 to come into compliance with the code sections in question. If the property is not brought into compliance by the date, a fine of $50 per day shall begin to accrue on December 13th, 2018, and continue to accrue until the date of the violator, that the violator provides the city with evidence that the property's been brought into compliance.
I'll second that.
Second by Mr. Newkirk. Any discussion?
In this case, I think, Steve, that fine is actually too high for, a backyard that hasn't been mowed. That's my opinion.
It was, I'll make an amendment, 25, I can see. Sean's cringing.
No.
I'll make an amendment, I'd like to amend my motion to the fine be $25 a day.
I'll second that part too.
45?
25.
25, okay. $25 a day.
Deal.
Okay, any other comment? There being none, I call for a vote. Excuse me, all in favor, aye?
Aye.
Opposed, nay, no nays. Thank you. And the last one.
Okay, the last case will be case number 18-4002, City versus Anthony and Jillian Moore for the property located at 941 North River Hills Drive. Case is before the board based on alleged violation of Section 828A1, permits application required. Case will be prosecuted this evening by Director Tom Baroni. City has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Tom Baroni, Code Compliance. This case this evening originated on September 14, 2018, from Community Development when I received a list of properties that were issued a stop work order. On September 17, 2018, I prepared a notice of violation for the electrical work that required a permit. Since the home appeared to be unoccupied, I posted the notice at the front door and requested copies be sent out certified in first-class mail. I also requested a copy be posted at City Hall for the 10-day requirement. On the 23rd of October, I received a phone call from the owner, Anthony Moore, that stated that the permit issue was resolved. However, in my records, it was still showing that it was still outstanding. I referred Mr. Moore to the permit coordinator, Ashley Kennedy. At this time, I would like to submit a screenshot of the stop work order from Community Development Records.
Board will accept.
As of today's check with the records, there has been no change and no permit was ever issued. So therefore, the property remains out of compliance.
Do you know if this is the owner or is this a contractor?
He's
mean,
the
did they have a
owner.
contract?
He's the owner,
He is the owner.
yes. I believe he lives in California also as well.
So he's not doing the work, probably?
No, this is a second home that he has here in Temple Terrace. And he's been working on this property for quite a long time. So,
Okay, thank you. Any other questions?
Any other dialogue other than October 23rd with the owner?
no, he was pretty persistent with me that the electrical permit was already issued. I guess he spoke to his electrical contractor,
Mm-hmm.
and the contractor stated that the permit was pulled, but it was never pulled.
And did I just hear you mention that he's done a lot of work? Had there been other permits on this property pulled?
Yes.
Okay.
Yep.
So he's fully aware of what needs to take place?
Yeah, yeah.
Okay.
Now, one of the things that the city does when they when a permit is pulled is there's a requirement for the permit to be posted
That's correct.
at the residence. So there should have been a posting if there really was one.
A lot of the contractors,
Hold them in their truck?
roofing contractors, they'll forget, they'll leave it inside their vehicle. They request that they post it on the window, but not all contractors do that. I mean, that's all.
All right,
We don't go by that.
good answer. Thank you. Any other question? Mr. Snelling?
So was the work was completed, or what exactly were they doing?
I don't know. When we get an email from community development, they just tell us the address,
Yeah,
a stop work order, and when it was issued, and it just says the permit, what kind of permit they're required. So it just says electrical permit required. They don't get into great details, and they don't break it down for us. But all I know is the work that was done requires electrical permit.
okay, thanks.
Are there any other questions? There being none, call for a motion.
Oh, you got it, or you want me to? I'll take the weight back on this side. Sorry.
Mr. Lloyd?
All right. Based on the testimony of Code Compliance Director Tom Barone presented to the board at this hearing and the documented evidence received by the board, I make a motion that the board find Anthony and Jillian Moore in case number 18-4002 to be guilty of violating section 8-28 subsection A subsection 1 of the city code. Give the respondents until December 12th to come into compliance with code sections in question. If the property is not brought into compliance by that date, a fine of $40 per day shall begin to accrue on the day following and continue to accrue until the date the violator provides the city with evidence that the property's been brought into compliance.
We have a motion. Is there a second?
Second. I'll second.
Second by Mr. Napke.
Any discussion on the?
Any discussion on the motion? Call for a vote. All in favor?
Aye.
Opposed? No nays. Also, in that case, just for the record, the respondent was not present.
When you're ready for unfinished business. Case number 181014, City versus Gregory Brian Milton for property located at 7818 Bolera Drive. An affidavit of noncompliance for sections 810213B, 810213C, and 1034 was submitted by Officer Allen dated October 11th. Case number 182696, City versus Superior Property Investment Ventures LLC for 8602 Grandview Drive. Expiration of compliance is tonight at midnight. An affidavit of compliance for Section 828A1 was submitted by Officer Silva, dated October 25th, 2018. Case number 183152, City versus Seva Development Services LLC for property located at 5108 Oak Haven Lane. An affidavit of compliance for Section 12921 was submitted by Director Brony, dated October 11th, 2018. Case number 183399, City versus Wells Fargo Bank N.A. trustee for 311 Live Oak Avenue. An affidavit of noncompliance for Sections 810213C, 810213H, and 810213K was submitted by Director Brony, dated October 11th, 2018. Case number 183407, City versus Estate of Antonio and Dukes for property located at 512 Caroline Street. Case, the expiration of compliance is tonight at midnight. Repeat case number 183920, City versus Craig Bernstein for 418 Ferncliff Avenue. Expiration of compliance was October 10th, 2018. An affidavit of noncompliance for Section 128592 was submitted by Officer Silva, dated October 11th, 2018. And I have two cases not on the agenda. Case number 171519, City versus Elizabeth Graham and Sharon B. Callahan for property located at 10317 North 53rd Street. An affidavit of compliance for sections 12860 and 1034 was submitted by Director Brony, dated October 22nd, 2018. And I have one more, and then Director Brony will update you on this case I just presented. And case number 182006, City versus Ayman Osman and Asma Alzine for 7442 Terrace River Drive. An affidavit of compliance for section 12860 was submitted by Officer Silva dated October 18th, 2018.
Just wanted to update the board on the North 53rd Street property, the Graham property. Several weeks ago, I met the owner of the property. She was an elderly woman. She, has oxygen. She's required to have oxygen every day, and there's definitely some hardships there. So I sent out I had my assistant sent out looking for a volunteer group to go out to the property, and we got a volunteer group that I just want to recognize, which was the Temple Terrace Home School. They sent 15 kids, approximately 15 kids, and 5 moms, and also the help from my staff. We went out to the property. We removed probably about 2 30-yard dumpsters full of debris from the rear yard. We mowed the property. It was just about 2 hours that required some heavy lifting, some sweat and stuff, but it was a good morning. The property, if you went by it probably today, it's just night and day, and it really looks really, really good. So I just want to say kudos to the volunteer group and the kids that came out and spent 2 hours of hard work. So that was the one affidavit that I put the property in compliance. Just another update I wanted to give you was the property on the unfinished business with 111 Live Oak Avenue. As of 2 weeks ago, that property is up for sale. So we just want to let the board know that there is a for sale sign on that property. Just also to update you on 108 Holland Avenue. Last week, Amir Anisi and I, the city attorney, Charles Stevenson, we had a meeting, and we've now put together a condemnation order. It's already been sent out. Today, in fact, I got the return green cards from the certified letters. The structure's been placarded, so we are moving forward with the condemnation of that property. So just to update the board as well on that property. And again, I just want to thank you for your work. I think there was an outstanding meeting tonight. Sir, thank you for the update on the helping the board, with again, we're pulling this, moving forward and getting together, and we're moving forward, and so I'm happy to see that. And so, Mr. Mueller, thank you very much. And thank my staff as well. And hopefully, everybody has a nice Thanksgiving, and I will zip it. But I just wanted to thank the property at 107 Greenfield, that has a $42,000 lien on that property.
I'm going to ask the chairman, but I can ask our attorney a question about that in a minute. But
Okay.
have you, I'm sorry, may I speak to, say something?
You
Tom?
are. Yeah, go ahead.
All right.
Mr. Lloyd, go ahead.
Are you planning on letting city council know about the day school going out and doing that work, and maybe recognizing them at one of the council meetings?
Yeah, we could,
I think that would be really nice to see.
Yep, okay.
Both, just for them to recognize that the group going out and doing that.
Yes.
It might invoke other groups to go out and do that for us as well if we need
Yeah,
it.
yep,
So, thank you. And thank you to whoever sourced that.
yes.
Thank you.
Okay.
I have one comment while you're up there, because I forgot a name, and also I didn't thank Lori for her presentation.
Okay.
And
That's
what's
Lori Smith.
Smith?
Yes.
That should be pretty easy for me.
Yeah, yeah,
Thank you, Lori,
yes.
and thank all of you. It's been a good meeting. Thank you. Is there any other new business to entertain?
I just have a question regarding
Okay. I'm sorry.
procedural on something there. You had advised us on that the property that Co-Director Tom Brony just informed us of the dollar amount. And if I understand you correctly, we're not to take into consideration how long that property's been a plight to the citizens and the neighbors at all, even though, because it's changed ownership. So am I understanding that correctly?
Because the violation is against the property owner, and you wouldn't want to penalize a new property owner for the
So it's not on the property, it's on the owner.
Well, yeah, that's who your violator is the property owner. So to have a new if you were to have made part of the basis of a violation against that property owner, actions of a previous property owner, that would not have been appropriate.
Okay. And so the dollar amount, that would affect the dollar amount, because that's what it would affect my decision, would be the amount of the fine, probably. Since there was no, they testified there was no activity.
Right, and then going back, it's always, the previous violations of the violator.
Okay. Thank you.
Unless there was a lien on the property prior to the new owner buying it. If there was a lien on the property and the new owners came to know that there was a lien on the property, the city has a lien on that property, and they came forward to us for a lien reduction, then it's different. Then it's appropriate.
Let me think that one through for a second. If you had a fine reduction and a new property owner was coming in, which we've had a couple of times this evening, I think you guys handled it appropriately. You just reduced the fine, and I think you took into account the fact it's a new property
Right.
owner. I hope that was
Well,
answerable
that's
to your
kind of the
question.
answer I was looking for.
Yeah, all right.
All right, any other questions? Mr. Napke?
Following up on Sean. Following up on Sean's question. So in the case he was discussing, the outstanding fine wouldn't transfer to the new owners, is what you said. Would it transfer with the former owner if he owned another piece of property in the city?
I didn't say that, okay, in a case where there was a lien already on a property, and we have a new owner that purchased that property, and that lien didn't get satisfied during that transfer, that lien transferred over to the new transferred with the property to the new property owner.
Okay.
What we're talking about is there was a case today where there was a new property owner, the violations were against the new property owner. I was saying that it wouldn't be appropriate to take into account the violations on the property when it was with the previous property owner when you were assessing a fine.
Okay, then let me ask it a different way. The previous property owner who had violations, if they owned other property in the city, could you fine them for, never mind. I'm complicated.
We're following your path, we're following it. Go ahead, Ryan.
He's asked,
I think I know what you're saying.
Okay, help me out here, please.
We could foreclose on the old property owner on some other property he owned in the city. So I can foreclose on the lien and foreclose on some other property he owns in the city or even within the county. So the lien, though, does run with the original property, but it doesn't mean that I have to foreclose on that particular property. I can foreclose on some other property that old owner owns,
Okay.
okay?
I thought you were asking if the property owner had other property with violations. Okay, so that was not what you're asking. Okay.
Excuse me for
I won't even
rambling.
go down that road.
Yeah. You've answered the question. Thank you.
Okay.
It brings up another question for me then.
Yeah.
Okay, if you're in the process of foreclosing on a property, that other property that this violation was, the lien was against, but the lien transfers with the new owner, and they come before us for a lien reduction, how does that fit in?
Well, I'm thinking that's what happened tonight. Essentially, the lien itself, it doesn't transfer anywhere. It pretty much stays on the property.
Yeah.
Now you have this new owner, like tonight, who came along, picked it up on a tax deed sale, didn't bother to ever find out that they were buying a piece of property with a lien on it. And so they come in basically as a naive but innocent purchaser because they didn't cause the original violation. They aren't the ones who let the lien run up. So they came in, threw themselves on your mercy and said, basically, I'm a new owner, but now I've got this piece of property with a big lien on it. Please reduce that. And you did. So,
So that's done.
that's done, and the lien will be removed from that property, and in doing so, the person who incurred that lien in the first place, they're done, never to have anything done to them about that particular lien again.
Excuse me. Sorry.
Don't eat.
And the reason I didn't ask further questions on why the lien was no longer on the liens list or anything like that, because it was not evidence pertaining to that case and that owner. Now, I will probably ask what happened to the $42,000 on the lien, but that was not relevant to that owner and property. Is that a safe assumption, is why I didn't bother to ask continuous questions on where the $42,000 went and so forth? That's just the reason I didn't pursue it any further, is because it was not evidence to the new owner. Now, I will probably ask the city manager or the city attorney what happened to that lien amount, and did it go with the tax deed sale or whatever, but that's not something for the new owner to be considered. Is that correct?
Well, right, I mean, if that's the way, just, the key is if you were to vest it, you know, it isn't inappropriate, but just to ask the question, but if you would have factored it into your decision, that's where you have an issue. And I wanted to kind of chime in on the tax deed since that's come up. And normally, when there is a tax deed sale, it does wipe out the liens on the property, except for municipal and county liens of record, which a lot of times gets missed by people when they purchase it. So your municipal and county liens of record do survive a tax deed sale.
Board Member Lloyd, to your question on the lien, Officer Jose Silva just meant it was no longer accruing and no longer accruing on the active liens list. It's still on the outstanding liens list right here for the $42,400. So they still owe the city that $42,400 lien.
And if I could go back to something earlier this evening, and Mr. Lloyd had a question. I indicated to him that I would talk to him afterwards, but if I can address that now. In looking for a procedure going forward on letting me know that you're interested in foreclosing on any of these liens, if we could sort of do it in two parts. If you come up with, let's start off slowly, please, but if you come up with one or two that you are interested in us looking into on foreclosing, then make that suggestion at one meeting, and give me an opportunity give me 30 days basically before the next meeting, that I can maybe do some preliminary investigation on that won't cost the city anything, rather than do some full O&E, hire somebody to do an O&E report for us. I can use the internet and try to at least find out about mortgages or something that may exist on the property. Then I'll come back at the next meeting and try to tell you what I found, if anything, and based on the information I give you, then you'll have a little more information about that property to go on, and then let me know whether you are still interested in moving forward and will, on that particular property, to start doing a foreclosure action on that. We're getting some new liens that are recorded, so letters have not been sent out to those people. If it's one on your list that's been there a while, the initial letter has already been sent to all of these people, so we're already one step ahead on all of those. That's why you're seeing more of these come forward each month than maybe before, rather than one or none. You're seeing probably two every month, and they're still coming in and questioning. We're finding out that some of these went through a foreclosure and the lien got extinguished. We didn't even know. So that's coming up too, so.
I think that's appropriate. I think that we can pose a question as a question, not as a request for a foreclosure. And then if we come in with information that it's a reasonable request, then we would make that request.
Well, I was going to maybe ask this, not at this meeting, but is there a legal requirement that it's on the agenda that we're considering that, so that the property owners are kind of, it's on the agenda, this property is being discussed, so that if anybody wants to speak to that case being foreclosed on, or us thinking about it. And I don't, again, I was going to do that for the next meeting, but I do like that suggestion, what
And,
you
and
said.
if you kind of just suggest which ones to look at, then that can be put onto the next agenda, then I'm gonna give you a report on that, and that will then the person know
So
that it's at least on the agenda.
So we could do that just in open discussion, like,
No, I
as
was
we're
going to say,
discussing the
if-
liens list.
If you're going to ask her, or as she likes to say, suggest.
Yeah, make a
but
motion.
it should be done, it has to be done by a motion.
Yeah.
As a
Yeah,
board,
that's
you
what I
can only
mean.
take action through motions and, it's that way, so whether it's suggestion, I was thinking it'd be, to have her conduct a preliminary investigation, something along those lines.
Can you write that up?
I will take a stab at it.
And maybe
Okay.
this is where we do it, in the new
Yeah.
business, we just say, collectively, we have a discussion on properties, and somebody brings it up, and we make a
And we make
recommendation
a
during
motion.
new business.
I think that's great. Agreed? Okay, is there any other discussion, or can I call for a motion to adjourn?
I'll make a motion to adjourn.
Second?
I'll second.
Second by Mr. Newkirk. All in favor?
Aye.
Oppose? No nays.
Yeah.